Welcome to the Appellate Division First Department. We have many hours of argument this morning, so I'd ask that you only request the time that you actually need for your argument. We have carefully read all of the briefs, records, and papers and are familiar with your cases. People versus Simmons. Appellant? Respondent? Han versus New York City Transit Authority. Appellant? Respondent? I'm going to do 6, 1, and 6. Mohammed is submitted. Facade Technology versus CNY Construction. Appellant? I'll give you a little time for rebuttal. Okay, respondent? Okay, 6, 1, and 6. Mount Builders versus Perlmutter, appellant?
6 and 2, please.
Respondent? 6, 2, and 6. Caban versus 1691 Fulton, appellant? Respondent? The respondent? Okay, 3 minutes. People versus Kelvin R. is submitted. Badzio versus East 68th, appellant? I'm sorry, what?
Appellant respondent, Jacobs and D'Angelo. I'm going to ask for 8 and 3, please.
Respondent?
Respondent Badzio, 4 minutes.
6, 2, I'm sorry.
Respondent E68, 4 minutes. Respondent 3 and 1.
You have a cross appeal?
Yes. Appellant respondent, same way.
Okay, 6 and 2, 3 and 1, 3, 3, 3 and 1, and 3. Winiarski versus Butler Jr. Respondent?
I didn't hear what Appellant said.
I'm sorry, what? 6 and 1.
6 and 1? 6 and 1 for respondent as well.
You have a cross appeal?
No, sorry,
6, 1, and 6. Rodriguez versus New York Cross, appellant? There is no respondent, so do you want to submit it? Okay, thank you. Submitted. Cavalino Consulting versus Steiker Corp, appellant? I'll give you 6, 1, and 6. God bless you. K and Children is submitted. People versus James Davis, appellant? Okay, it's submitted. Elena Simone Inc. versus Madden is submitted. Schultz versus Cambridge Development, appellant? No respondent? Okay, I'll give you 3 minutes. Do you want to submit it?
There is one thing I want to say.
Okay, 3 minutes. Community Association versus Butts, appellant?
Appellant Emerson, Howard and Butts, 7 and 2.
Appellant Sozio and Ariel, 6 and 3.
Is anyone else here on it? Okay. 7, well, are you opposing each other?
No, we're appellant.
Oh, I see, I didn't see you, I'm sorry. Do you have a cross appeal? I'm sorry, do you have a cross appeal? Okay, 7, 2, 6, what? No, okay, 7, 2, 6, 2, and 6. People versus Natal is submitted. Foley versus O'Neill, appellant. 6, 2, and 6. 60 East 9th Street versus Zaheni is submitted, and Cresco Labs is submitted. So the first case will be People versus Simmons. Nobody wants to argue?
Sorry, Your Honor.
You're getting comfortable over there, huh?
Good morning. Karina Rahal from Office of the Appellate Defender for Frankie Simmons. Your Honors, in this case, the trial court erred when it certified Mr. Simmons as a sex offender as part of the judgment of conviction because the plain language of Corrections Law 168A does not include first-degree assault on the list of registrable offenses. This court should therefore vacate that certification. 168A lists the offenses that are registrable, and 168A sub 3 requires registration for any sexually motivated felonies in the, quotes, foregoing sections of the statute.
Counsel, there's no dispute, is there, that this issue is preserved?
This issue was preserved at plea and sentencing. It was litigated and
briefed,
motions
correct?
were filed.
Yeah, thank you.
Yes, by the trial defense attorney, and the trial court heard arguments on the topic. To read 168A to include first-degree assault as a sexually motivated felony would modify the statute. And that's why the overwhelming majority of courts have sided with our position on this issue, finding that the statute is clear and unambiguous.
If we give the Romanet 3 its plain and unambiguous meaning, as the statute is written, what effect does it have?
Well, it has the effect of making the offenses that are listed in sections 1 and 2 registerable.
But aren't they already registerable under 1 and 2?
If they are listed there, then they're registerable.
So
If
they're registerable under 1 and 2, and then 3 confirms that certain offenses are registerable under 1 and 2?
That's correct. So sexually motivated felonies that are among the list of registerable offenses, people have to register for those. So when the statute is clear and unambiguous, that is where the court must turn. The people take the position that this court should look to legislative history and intent. But the cases that they cite hold that that can and should be done when the statute is vague or unclear. Here we do not have that issue. Moreover, this doesn't
You're saying
have...
Section 3 is so clear that we should not look at all what the intent should have been, because it doesn't make sense on some level that all of these sexually motivated felonies would not be included under SORA. But you're saying we can't look at any of that, we just have to look at what the language says because it's so clear-cut, Section 3?
Well, the issue is that there are non-sex offenses listed there, and there are other sex offenses that aren't listed there. So for the court to step in and assume what the legislative intent would be is wrong when the language is
Look at a case like ours, which seems pretty clear that this is the type of offense that would normally be included under SORA. How could it have been the intent of the legislature not to include it?
But there are other things that seem like they would be also. For example, sex abuse in the 3rd degree is not registerable. Surveillance, unlawful surveillance, is not registerable. Kidnapping, where there is no sex offense involved, is registerable. Now, the point that I'm making is that it's not for this court to assume what that intent was if the language is clear. Here, there have been 14 years of litigation over this topic, and the state legislature has taken no action to change, to simply add subparagraph 4 that might say all sexually motivated felonies are registerable. It would be that simple a fix. And since they haven't done that, this court should not step in and do it for them.
What effect, if any, does yesterday's decision from the Court of Appeals in Bouillon have on this appeal?
None, in short. So the Court of Appeals yesterday did not decide that case on the merits because it found that it wasn't preserved, that the issue was not part of the sentence, but was part of the judgment of conviction instead, and therefore didn't fall into the illegal sentence exception for preservation. So Bouillon yesterday in the Court of Appeals said AD2 could take this up substantively in the interest of justice, but because it wasn't preserved and because we find it wasn't part of the sentence, but rather part of the judgment of conviction, AD2, it should be sent back to AD2 to make that determination. So they didn't reach the merits because they found it was not reviewable. Here, it's reviewable because it was preserved as part of the judgment of conviction. I'd like to just address the excessive sentence issue as well, Your Honors. In this case, my client was sentenced to 12 years with 5 years post-release supervision on a first offense. That was 7 years above the minimum. He had shown deep remorse. He had a lot of family support, father of 2 children. He was young, in his 20s. He had admittedly a terrible drinking problem, but he also had a strong employment history. And since his conviction and sentence, he's taken accepted responsibility throughout the case from the very beginning, and he's taken part in counseling and every other program that he could.
You can finish up on rebuttal with the excessive.
Okay, thank you.
May it please the court, I'm Philip Tisney for the respondent. Defendant's interpretation of the correction law directly conflicts with the legislature's intent and would lead to absurd results.
What about the argument, though, that the language is unambiguous on its face, and since it's unambiguous, we never get to the issue of looking at the legislative intent?
Well, I agree that the language in the statute literally read supports their interpretation, but that's the same situation that the Court of Appeals confronted in People versus Santi, which is the critical case here. The statute in that case also was sort of literally clear, and yet the court said we can look beyond the literal text of the statute when that conflicts with the legislature's intent. That's this case. This is a rare case, it's an extraordinary case, but this is one where I think nobody disputes that the legislature intended to make all sexually motivated felonies registrable under SORA. Even the decisions that have adopted the defendant's position did so acknowledging that the legislature's intent was otherwise.
So the Second Department decision, it has been remanded now to be reconsidered on the interest of justice, but what about the analysis that the Second Department has already rendered on this, which is a pretty detailed opinion about why the statute is unambiguous and why we should not look to legislative history? Why shouldn't we follow that guidance from the Second Department?
Well, because Bryant committed the error that I think Santi makes clear courts don't need to make. Bryant felt like it was constrained, like the other courts. Lawrence in New York Supreme felt constrained by the language of the statute to interpret it in the way that defendants suggest it should be interpreted. But Santi makes clear that in certain rare situations, courts can look to the legislature's intent when that conflicts with the literal interpretation of the statute. Whether the Second Department adheres to its decision on remand is really beside the point, because this court certainly isn't bound by that decision, and the reasoning we think is flawed. Santi, I think, is important for 2 additional reasons. The first is that in that case, you had a fairly thin record of legislative intent, nothing like the record that you have here. Like I said, there's no real dispute about what the legislature intended with respect to sexually motivated felonies. The other thing that's important about Santi that you have to keep in mind is that was a statute that imposed criminal penalties. That is a context where arguably the costs of poor draftsmanship should probably fall on the legislature. And yet, even in that situation, the Court of Appeals held, no, we're willing to look beyond the literal interpretation of
Do you
the
think all
statute.
courts have that prerogative? You're saying that the Court of Appeals did it. Do you think all courts have that prerogative when a language of a statute is clear to say we're going to disregard that clear language and look to the legislative intent?
Well, and just to be clear, yes, this court does have that power, and I'm not suggesting that you should disregard clear text. What I'm saying is that the literal text of this statute produces absurd results that renders that literal interpretation untenable.
But what about the argument that the legislature has had ample opportunity at this point to correct it, since it is pretty clear on its face that it doesn't include an offense such as the one in this case, and the legislature has not chosen to come back and fix the legislation? Why should the courts do it if the legislature is not willing to do it?
Well, there's a couple of responses to that, I think, Judge Kern. The first is that in the legislature's defense, the decisions interpreting the correction law have only recently sort of percolated up. Byand was the first appellate decision on the issue. The only other appellate authority sort of remotely touching on this issue was this court's decision in Rodriguez from 2012, and that went in the way that we say the legislature wanted it to go, so there would be no reason for the legislature to feel like it needed to fix that.
Why shouldn't the legislature do it now then? If there is this clear statute that we have to interpret, why shouldn't it be the legislator who says, oh, there's a problem here, the language is clear, it doesn't include these offenses, why should we take that away from the legislature?
Because doing otherwise would be giving a windfall to violent sex offenders on the backs of the security and the safety of communities, all based on a technicality that everybody agrees the legislature didn't intend.
So how would we decide which offenses would be included and wouldn't be included? Because it is very specific what offenses are included.
Well, I think the
Why
legislature...
then one versus another?
Exactly, Your Honor, but the legislature was clear that it meant for all sexually motivated felonies to be included. And there is a way to read the statute that effectuates
That would be such an easy thing for them to say if that's what they meant. I mean, it would be very easy to use that language if that was their intention to use that language, and they didn't use that language.
Well, to be fair, they did use that language in the bill jacket. That's what they said in the legislative materials supporting the legislation. And I admit, candidly, that the way the statute is drafted more naturally, is read more naturally to support defendant's interpretation. But like I've said, there are situations, rare situations, where the literal text of a statute must give way to the legislature's intent, and this is one of these cases.
Sir, what is the absurd result?
So
If we were to read Romanet 3 and give it its plain meaning, what is the absurd result? Because I think if and only if it's absurd do we get to scratch beyond or beneath the plain language. So what is, you've used that phrase a few times, what is the absurd result?
Thank you for asking, and I see that my red light is on, but I'd like to respond. There are two ways that this results in absurdity. The first is that it renders the provision adding sexually motivated felonies to the statute superfluous. There would be no need to signify or to indicate that crimes that are already SORA eligible continue to be SORA eligible because they are committed with a sexual component. The addition of an intent to have sexual gratification, which is what the sexually motivated felony does, doesn't make something less SORA worthy. It makes crimes more SORA worthy. And so there would be no reason for the legislature to specify that charging something that is already a sexually motivated felony as, or I'm sorry, it's charging something that is already SORA eligible as a sexually motivated felony continues to make it SORA eligible. So that's one. The other one is that it means that the legislature intended to exempt from SORA registration a slew of very serious sex offenses: murder, manslaughter, assault, but it wanted to include in SORA registration some much more minor sex offenses like prostitution offenses, offenses having to do with promoting sexual performance by a child. These are obviously serious crimes, but they are much less serious than murder as a sexually...
Okay, I think we have your point. Is there
Okay.
any other questions from the bench? Okay, go ahead.
Thank you.
I just want to briefly address the issue of absurdity in legislative history. First of all, again, if the legislature found it important to include things that aren't sex offenses in the list, like kidnapping, somebody has to register if they're convicted of kidnapping a child, even if there's no sexual component to it at all. They didn't include other things that do have sexual components to them. So there's not a broad category of cases that's included. It's the reason there is a specific list, because they debated, discussed, and considered what was in the interest of public safety for registration purposes. This is why the court should not step in and make assumptions about a broad category of cases, because the legislature didn't do that. They specified specific kinds of cases after debate and consideration. Moreover, legislative intent and history includes debate, discussion, consideration of all kinds of amendments and things to include. This court should not look to that to determine what the final intent was, because then there's a final drafting, and that's where they have to argue and agree and come out at the end of it with a drafted piece of legislation. And it may not include all of the things that were discussed along the way. So I don't believe that it has an absurd result to do what the legislature specifically did, unambiguously, clearly, exacting language with lists of the kinds of criminal offenses they wanted included. To come in and say, well, no, actually, I'm sure they wanted this broad category included also. That should be for the legislature to determine. That's all I want to say about that. Thank you.
Han versus New York City Transit Authority.
Good morning, Your Honors. Boaz Cohen of the law firm Kramer Levin, pro bono counsel for third-party defendant and appellant Naeem Davis. May it please the court. On a subway platform, an angry and disturbed stranger explicitly and obscenely threatened to kill appellant Mr. Davis. When his repeated requests to be left alone and his attempt to walk away were unsuccessful, Mr. Davis pushed the stranger away. But the man was so drunk, he tragically stumbled backwards and fell into the tracks and was killed by a train entering the station thereafter. Mr. Davis was charged, denied bail, and detained at Rikers Island for 4.5 years.
Counsel, that last fact is particularly disturbing. I grant you that. However, this is a pleading motion.
Yes, Your Honor.
Haven't they pled the elements necessary?
So, Your Honor, now through a third-party complaint that is both facially deficient and refuted by the evidence, Respondent Transit Authority, looking to deflect liability, seeks to embroil the indigent Mr. Davis in the wrongful death action filed by the decedent's estate.
Counsel, the complaint alleges that your client pushed Mr. Han onto the track.
It does, Your Honor.
Why is that by itself not sufficient for pleading purposes? And we're talking about a pleading motion. We're not talking about a summary judgment motion. Why isn't that sufficient to allege a wrongful act which would support a claim for contribution?
Yes, Your Honor. So first, I would just note that it's not clear from the complaint itself whether the allegation is that Mr. Davis intentionally pushed him onto the tracks, or intentionally, knowingly, or recklessly pushed him onto the tracks, or just that he pushed him and that Mr. Han then fell onto the tracks.
Why isn't that enough for the pleading
Yes.
stage? I mean, that's a serious allegation. I understand that the story is very complicated and there's a lot more to it, but that is the allegation.
Yes, Your Honor.
That someone pushed someone else on the track. For pleading purposes, again, we're not talking about a summary judgment motion. Why isn't that sufficient?
Yeah, so Your Honor, I think that you need to, that the court should be looking at the other non-conclusory allegations, and there are really only two others. The first is that there was an altercation between the two men, and that during the altercation, that is when the push occurred. And the other is incorporated into the third-party complaint by their incorporation of their verified answer on the main action, in which they allege that Mr. Han was either wholly or at the very least partly culpable and responsible for his own injuries.
Right, but aren't you allowed to plead on the alternative at the pleading stage? I mean, they're allowed to say, we might prove this, we might prove that. We don't know yet what we're going to prove.
Well, Your Honor, so I think two responses to that question. The first is that I think here the underlying factual allegations, when you put aside all the bare legal conclusions, are so bare, so skeletal, that it's really all about an inference, whether you can give them the inference.
This is the nature of a contribution slash indemnification claim. We are not liable, but if we're liable, then we want you to also be liable. So you have to plead in the alternative in those type of claims.
So I understand, Your Honor, but what the court has, so I think that this is also a case where it's not as though the transit authority doesn't have all the evidence they could possibly need to be more specific in their complaint. They requested to unseal the record from the criminal trial, which has the prosecution presented 36 witnesses, over 100 exhibits. If they wanted to say if they wanted to show the court that there's really something here, that there might be, that the push was wrongful in some way, they could have said dozens of other things if they had anything to say. But the fact
Sir,
that they don't,
unfortunately, doesn't that, and as Justice Moulton indicated a moment ago, I mean, this is a very unfortunate set of facts and circumstances for Mr. Davis, but doesn't that cut both ways? Mr. Davis lived through this trial. He lived through this ordeal. He's not viewing this from the standpoint of a stranger who is served with a set of pleadings, bringing him into an action. He went through this ordeal. He was involved with this. He has notice, in a manner of speaking, from his own involvement, intimate involvement with this terrible ordeal. And now he's served with, as Justice Kern pointed out, a fairly common-looking impleader complaint.
So, Your Honor, I think that while we're not arguing that Mr. Davis doesn't have notice about what the transaction was, what the occurrence was, but it's the pleader, in this case, the transit authority, in their contribution indemnification complaint, for that cause of action in a wrongful death suit, to show that our client could possibly have any liability, they need to allege wrongfulness, wrongful action on his part. And all they've said really is that in the context of an altercation about which they give no additional facts, even though they have access to the complete record, we submit that the court should not be granting them a positive inference or a beneficial inference, especially in light of the fact that they're also pleading in the alternative that Mr. Han was completely culpable. And I think the second part of our argument, Your Honor, relates to the evidence that we've submitted. And I know Your Honor has written extensively about the submission of evidence on a motion to dismiss.
Extensively, but not necessarily accurately.
Okay. I'll leave that for you to decide, Your Honor. But it seems it's quite clear from the case law that a party can submit evidence on an A7 motion, and it's separate. It is a separate police procedural device from summary judgment. And Your Honor, I think we submitted tons of evidence, and the Transit Authority has responded upon it. And I'm not saying that they have to.
You're going to have a chance to address that further in rebuttal. Thank you.
Okay, thank you, Your Honor.
May it please the court, Tim O'Shaughnessy from Transit. The points I wanted to make about the pleading issue have come out. On collateral estoppel, the fact that Mr. Davis was acquitted by the jury means collateral estoppel. It does not mean collateral estoppel applies because the burden of persuasion was higher. Collateral estoppel also doesn't apply because Transit was not a party to the criminal proceeding. And finally, also because Transit was not a party to the criminal proceeding, the transcripts from the criminal proceeding are not admissible on this summary judgment motion. Thank you.
Well, I'm curious. So I would think necessarily your contribution claim has to rest on his intentional conduct, right? This isn't usually to get contribution, you can show any culpable form of conduct, which would include intentional, negligent action, et cetera. Here, though, it seems undisputed that Mr. Davis's act was intentional. He intentionally pushed Mr. Hahn intentionally pushed him and then unfortunately fell onto the track.
We pled negligence as well, and negligence would be sufficient for us to recover in this civil action. I don't know what, obviously second-degree murder requires intent. I don't know what any lesser charges he was charged with.
Well, I'm not looking at, and I don't think they argue collateral estoppel. I think they were very clear that they said, look, yes, we were acquitted. We're making an A7 motion supported by evidence. Here is this evidence. Admittedly, it comes from the criminal trial. My concern here is that I'm based on the undisputed facts here, as we understand them, the act of pushing was an intentional act. It wasn't negligent. He didn't negligently push him. He pushed him because he was being accosted by this man and he wanted to get him away from him. So he pushed him. That's an intentional act. And justification is a defense to the intentional tort of battery or assault.
Your Honor, the record contains absolutely no admissible evidence about what happened. The trial testimony is inadmissible. We do not have any affidavits from anyone. All we have are pleadings.
Was that admissibility argument raised below or in your brief? The admissibility of the evidence?
I'm not sure. I'm not sure.
Okay.
Okay, thank you.
Thank you very much.
Your Honors, I just want to address very brief points. First, just on the issue of the evidence, I don't want to get into what all the evidence was. It's in my brief. But I want to note that even if Your Honors find that the evidence does not establish conclusively that respondent has no cause of action, it can and should support your judgment that the conclusory nature of Transit's allegations in its third-party complaint is more than simply a matter of inartful pleading.
Counsel, excuse me, do you disagree with your adversary's position that you did not advance the notion that the acquittal was absolutely conclusive to defeat a civil action against your client?
So, Your Honor, we are certainly not arguing collateral estoppel. We are not arguing that the mere acquittal at a criminal action precludes a subsequent civil action. We are not arguing that at all. We are simply providing evidence, among others. The evidence includes an affidavit from the jury forewoman, an affidavit from Mr. Davis, trial testimony, statements by jurors to the media, which is admissible. It's in papers of record immediately thereafter, after the verdict, and other evidence, all showing both sort of 2 points, Your Honor. One, that Mr. Davis was in fact justified. The evidence is overwhelming that he was justified in pushing Mr. Hahn to get him away from him. And second, that the jury so found, that not just that the jury found that the prosecution didn't meet its burden of proof and therefore acquitted, but that the jury actually found, and the jury forewoman, who better than the jury forewoman who sat through a 3-week trial and mediated any possible disagreements amongst the jurors during their deliberations, who better than her to say, as she says in her affidavit, that she does not believe that any reasonable jury could conclude that it's more likely than not that Mr. Davis acted wrongfully. So we are certainly not arguing collateral estoppel, Your Honor. And I just wanted to provide...
Thank you. Your time is up.
Okay, thank
You have
you.
your arguments. Facade Technology versus CNY Construction.
Good morning, Your Honors. May it please the Court, my name is Jason Copley, and I represent Facade Technology. This is an appeal from the denial of a motion to certify a class action to enforce a trust pursuant to the lien law, as required by Section 77 of the lien law. It was denied as being untimely. Facade Technology is an unpaid subcontractor of defendant. It has
Counsel,
a
why
lien.
hasn't Facade established a good cause for allowing the not very late class certification motion?
Your Honor, the good cause, as found by this court in Girard, includes the very limited time that went by, the 21 days, together with the fact that the motion to certify was filed within 60 days of an amended answer filed by defendants, and also the fact that prior to these filings, defendants had had requested and received a stipulation to extend the time to answer, a fact looked at in Girard, which is actually not a lien law case under a more stringent standard under the class action rules of 901
Wasn't
and
there the class
902.
certification motion filed shortly after CNY filed its amended answer?
It was filed 60 days after the amended answer, Your Honor.
Okay, it was 60 days.
Yes. So the reason that this is so important is that the trust fund claims are important to contractors under the lien law so that they get paid for the good and valuable labor and material they provide to jobs. And the legislature gave the right to subcontractors who do this.
Counsel, just a point of clarification. I think what you're asking us to do, if we agree with you, is to remand, correct?
Correct, Your Honor. And that is based on the as near as may be language that is clearly identified in the Section 77 requirements. They have not been strictly construed. I've not seen any cases where a lien law certification request was stricken because of lateness. There have even been times in other cases cited in our papers where they were at trial or before trial and they were sent back to allow time to certify. And in this case, there had been no procedure in the case. The note of issue had not been issued yet, and the pretrial conference order didn't get entered until November of 2020. So the record at page 312 shows that the Section 76 disclosures of defendants was inadequate. It was merely a statement of payments that were made to Facade, and it didn't permit Facade to evaluate the subcontractors and also how payments were made by the owner to this single purpose entity general contractor. And the court did not consider that. And clearly, by depriving Facade of a proper statement, it inhibited its ability to evaluate it and allege essentially specific misappropriation.
Go back a minute to something you said earlier. Are you arguing that there is a different requirement for class certification timeliness analysis when it's a lien law versus other types of class actions, that the requirements of CPLR 902 should not be strictly construed? And if so, what is the basis for that argument?
Yes, Your Honor, that is exactly the argument because section...
What's the basis for that?
Yeah, 901 and 902 are very strictly applied throughout class action law. Under the lien law, clearly the legislatures did not intend for it to be strictly applied. They could have said...
Doesn't the lien law say that it requires compliance?
It does,
but it says... The procedural requirements of Article 9?
It does, Your Honor, but it says as nearly as may be. And in order to give those words meaning and not render them superfluous, you have to look at not only the body of case law, but the actually intent of the legislature. These are not voluntary class actions brought by contractors who are trying to get Section 76 information. It's compulsory that a contractor bring a class action, which is very different than a voluntary class action. So by the mere nature of it not being provided with the information that it was entitled to, meaning Facade, it had to bring a class action to enforce that violation. And in order to do that, it has
Counsel,
to...
let me interrupt you for a second. Section 77 also has a relaxation of the numerosity requirement, correct?
It does, Your Honor.
That's explicit, placed in there by the legislature. Couldn't they have been more explicit about the 60-day deadline?
Well, we believe that as near as may be, and this court in the West End case allowed one 6 months after the date had passed. So it's not a matter of first impression before this court, and there are cases in the second and fourth departments that also allowed such filings in order to assemble a class. And here, by not allowing this matter to proceed, the defendants essentially are going to benefit from not providing the information to Facade Technology so that the class and the information could be evaluated, the specific books and records that are required to be kept by the lien law, the very information that the contractor was entitled to at the time of the request for, under Section 76.
Well, let's assume you don't get any special treatment or dispensation because it's a lien law action and you have to comply with 902. Could you nonetheless seek some refuge in CPLR 2004?
Yes, and that's in our papers, Your Honor. We also rely on 2004, which under the Girard case, they looked at the fact that an amended pleading had been filed. In that case, it was 17 days. And again, that was a strict compliance requirement for 902, and it was 17 days late, and permission was given based on some of those factors which are present here.
Thank you, and you'll have a chance to finish up on rebuttal.
Thank you, Your Honor.
Good morning. May it please the Court, Joanne Bonacci from Dreyfus, Bonacci, and Parker on behalf of the respondents, CNY Construction, 701 LLC, Kenneth Caleo, Stephen Caleo, and Dennis Prude.
Okay, I think I confused which side was which when I asked my first question initially, so I'll ask you the question that was intended towards you, which is, why haven't they established good cause under CPLR 2004 to proceed with a late class action certification?
Yes, Your Honor. In fact, the appellant hasn't established any cause at all, let alone good cause. This action was filed after the complaint was filed. 15 months had passed before they filed their motion, 11 months since the first stipulated responsive pleading, the motion to dismiss on October 23rd, 2019, and 81 days, Your Honor.
But how long after the amended answer was filed?
The amended answer, Your Honor, I think it was approximately 21 days, but it's 81 after the answer, which the
And isn't it correct that they are arguing that the delay, at least in part, was due to CMY's delays in providing substantial responses to their requests about the lien law verified statement?
No, Your Honor, there can be no merit to that whatsoever, because in their complaint, when they filed their complaint, they based their claim against CNY at the time on the fact that a verified statement, response to a verified statement demand had not been made. Once we were in litigation, a response to the verified statement had been made, and it had been made before a motion to dismiss had been filed. So some 11 months, Your Honor, before they proceeded. And it was important to the motion court that in a comparative action, the Natixis action, a foreclosure action, there are 17 other lien claimants that are in that action. That action was filed in 2019, toward the end of 2019. Appellant is in that action along with the other lien claimants. None of those lien claimants, who are all represented by Construction Counsel, have made an Article 3A claim. So they were well aware of the other lien claimants, as they were already in another action going on at the same time, for which respondents are also parties, Your Honor.
To what degree, if any, were you prejudiced by the late motion?
Your Honor, the prejudice is severe in this action, because there have been over 800,000 pages of documents that have been exchanged in the underlying action. And there are 3 individuals that have been named in this Article 3A claim by the appellant. Those 3 individuals are sustaining legal fee, etc., in connection with this. There is no basis, Your Honor, with all due respect, to overturn or nullify a 902 CPLR requirement, which clearly has a mandatory 60-day filing. There simply is no cause, nor has there been anything. If what appellant is asking this court to do is essentially nullify 902, to say that somehow for an Article 3A claim, the 60 days means something different than it does for any other class action claim. And that's not what the legislature said. The plain meaning in the words of what the legislature has said is very clear, Your Honor. The legislature says that in 77-1, which I would point out to the court, 902 was enacted after 77. And 77-1 was modified or amended to specifically reference 901A, numerosity. And the reason, Your Honor, why numerosity was enumerated there specifically is because there's some projects that 3A applies to that are very small. They may only have 5 subcontractors. If that's the case, it may not otherwise qualify for numerosity. So they say, okay, Article 3A applies, numerosity is your exception, not 60 days. What appellant has not said to this court, and nor is it in anywhere in the papers, nor was it in the underlying motion that did not convince the judge, is why didn't they file within time? And that question has yet to be answered. And I think that that's very significant for the appeal. In addition, it was important to the underlying court that the sole basis for their claim is the actual wording of the verified statement. It was also important to the underlying court that when CNY responded, CNY put forth evidence, certified evidence of $28 million of payments, which exceeds the lien claim of the appellant. The appellant's lien claim differed by...
That's not the issue before us today, though, right? The only issue that we're deciding today is the timeliness of the class certification motion.
Your Honor, I think the basis for the court's ruling was very clear, and it did include that fact. It also included the conflict and the adequate representation because of the conflict of interest and the nitixis piece of the other 17 lien claimants that existed at the time. So
I
yes,
think what Justice Curran is saying that there's an inquiry as to the timeliness, right? That's one discrete inquiry. And then there is the Article 9 more substantive type elements. And we're looking at box 1 right now.
Your Honor, I think you have the discretion to look at the entirety, as did the underlying motion court.
Okay, thank you very much.
Thank you.
Very briefly, the trial court did hear argument and responses to the arguments that counsel just referred to regarding the eligibility of Facade to be a class representative and chose to issue an order that was clearly and only based on timeliness. So
And that's your position, right, that that is the only issue for us to decide on appeal is whether or not the class certification motion was timely.
correct, whether it was properly denied, and we simply
Because it
asked,
wasn't actually a decision on any other aspect of the
correct,
application.
and we simply ask that this court give meaning to the words "as near as may be," because we searched and there's not a single other statute in the state that has that language. If it doesn't mean there can be a relaxation.
You're otherwise arguing that you meet the requirements under CPLR 2004.
I'm sorry, couldn't hear you.
You're otherwise arguing that you meet the
Yes.
requirements under 2004.
That is correct. And the legislature did not say conform, it didn't say follow, it said as near as may be, and we believe those words have meaning. Thank you, Your
very
Honors.
much. Mount Builders versus Perlmutter.
May it please the court, Simon Rothkrug for the appellant. In this case, the zoning board euphemistically uses the term a course correction for its decision to abandon the general city law. The zoning board decided that it didn't like private streets, doesn't like private streets.
What's wrong with that, though? What's wrong? I mean, and they were very explicit about it. It wasn't a hidden agenda. They said, we're changing direction. Why aren't they permitted to do that, where they very clearly explained why they're changing direction and provided arguably a rational reason why they were changing direction, that it didn't work the way they were hoping it worked, and the statute supports their current approach.
A couple of responses. In 2011, the city planning commission, the city council, the legislature of the city of New York weighed in on the question, and they adopted section 2620 of the zoning resolution, which allowed the development of private streets. It set forth explicit guidelines, building standards, width requirements, a very extensive section in support of private streets. Then New York State also weighed in 2015, when it actually expanded general city law to allow a more liberal application of permitting residences that didn't front on map streets. Said both the state and the city weighed in on it. As far as what the zoning board did in this case, they didn't rely on, and I'd say in my briefs that they made up explanations. There's no empirical evidence, there's no data. It was simply a decision that they don't like homeowners associations, they don't trust homeowners associations to take care of private streets. They don't like private streets, not based on any studies, not based on any facts. Clearly, in this case, it was based on nothing more than political pressure.
Putting that aside, what in the language of General City Law 36.2 supports them not being able to do that? What in the face of the legislation does not allow them to come out with the result that they're coming out with now?
Well, the crux of the zoning board's authority is to exercise discretion. But you can't exercise discretion by abandoning the law. That's not discretion. That's changing the law. That's legislating. And that's what they did here. They decided they don't like private streets anymore.
How about that they decided that they were interpreting it incorrectly before, and now they believe they're interpreting it correctly? And that's why I'm asking you to give a contextual argument that's grounded in the language of the general city law, rather than they change direction.
Well, in the general city law, it speaks to practical difficulty or unnecessary hardship. Discretion should be exercised. And the zoning board has the right to make a reasonable determination, make reasonable conditions.
But is financial hardship, which is what you're primarily arguing, a reason in itself to find that standard has been met?
Well, we're not arguing financial hardship. We're really arguing the practical difficulty standard. You have a unique site here. You have a unique site that has 15.5 acres with no streets in it. There's no way to access a 15-acre site, which is very deep, without creating some private access roads. It's impossible.
But what about the finding that's pretty clear on the record that you could have either built multiple dwellings, formed multiple dwellings on the property, or you could have developed the streets according to the city requirements and then obtained mapping approvals, so that there were other alternatives available for your client to be able to develop the property?
The reality is there were no alternatives available. On page A478 of the appendix A478, we submitted a theoretical plan with a theoretical development showing various multiple dwellings. Even those multiple dwellings required access roads. They required long driveways. These driveways were de facto streets. The reality is, whether you call it a street or a long driveway, there was no way to access the property. Additionally, the buildings on that theoretical site plan were geometric, gymnastic buildings with crazy shapes. And even on that theoretical site plan, we were unable to access about 50% of our property. The 50% in the rear was inaccessible, which
Counsel,
again is a practical difficulty.
Sorry to interrupt you, but what are we to do with the fact that the fire department objected, DOT objected, DOB objected, and DEP objected? And you say in your papers you could have satisfied those objections, but why does the BSA have to wait for you to do that?
Well, again, the record clearly shows that the fire department, we met our deadlines to submit responses to the fire department objections, which really were for sprinkling the buildings. The fire department received those papers on time. The fire department came to the last hearing and said, we're still reviewing the paperwork. And the zoning board said, we're not even going to give you time. We don't even care. Actually, in my brief, the zoning board said, we understand you will most certainly be able to meet the fire department's objections. They acknowledged we would have met their objections. So I think that's a red herring to say that the fire department objected, when the BSA acknowledged that we would have met their objections.
Okay, how about the other agencies?
DOT didn't really object to this. DOT does not, the reality is that the Department of Transportation does not want new streets. And as we said in our papers, there have been no private street mappings in over 50 years in the city of New York. And that's because the city does not want to take the added responsibility for maintaining new streets. They would prefer that private developers and homeowners associations take the responsibility for those streets. DEP is not an objection. It's a matter of, again, it would be the infrastructure would be created by the developer. These were not objections by these city agencies.
You'll have a chance to expand further on rebuttal if you wish on that point.
Good morning, Your Honors, and may it please the Court. Ben Pollack, Assistant Corporation Counsel for the respondents. The BSA rationally found that petitioner failed to establish either a practical difficulty or an unnecessary hardship in constructing on the site in compliance with GCL Section 36.2's requirement that new buildings have access to mapped streets. Now, petitioner wants to talk about a 2011 City Council amendment and GCL Section 36.3, which is not at issue here. I would point out very quickly that the City Council amendment from 2011 was raised for the first time in reply and is not properly before this court. In any event, the idea that a City Council amendment would somehow preempt a state law and the clear text of a state law clearly has no merit. Now, this court only needs to answer one question.
Counsel, that 2011 zoning resolution, though, doesn't it at least show some endorsement of projects such as the plaintiff's petitioners?
Your Honor, this argument was raised at the 11th hour. We have not had an opportunity to brief it, and frankly, we don't think that it's relevant to what the state legislature intended, very clearly intended in its enactment of GCL Section 36. I would also point out that Section 36.3, the 2015 enactment that petitioner has referred to here, basically what the legislature said is we have some private streets that already have dwellings or buildings on them. In those limited instances, it makes sense. It's acceptable to put a new building on this pre-existing street. That's completely different from allowing someone to build an entire subdevelopment on 3 private unmapped streets. Now, I would also point out that Assemblyperson Cusick, who sponsored that 2015 provision, GCL Section 36.3, is one of the people who submitted written testimony in opposition to petitioner's planned development. And Assemblyperson Cusick expressed his clear view that the spirit of GCL Section 36.2, the only provision at issue here, is to, again, really only allow narrow exceptions to the street mapping requirement, and only when practical difficulty or unnecessary hardship have been demonstrated. Now here...
Well, what about your friend's point that the objections that were raised as the foundation, or the rationale for the foundation for the BSA's determination that no exception was warranted, were really based simply on generalized concerns, be they fire, be they street maintenance, street congestion, and not on any sort of specific or founded evidence?
Yes, Your Honor. So the record has ample evidence that, as Your Honors have mentioned, multiple city agencies expressed concerns. The fire department said quite explicitly that the scale and the nature of this development would create a quote-unquote undue hardship on the department in the event of emergency operations. The BSA considered ample evidence and also itself conducted site visits to communities in Staten Island built on unmapped streets that really convinced it. And this is an expert board, right, comprised of 5 experts, as this court has recognized. And the BSA was convinced that private unmapped streets have very serious issues with street maintenance, with parking enforcement, with infrastructure repair, with repairing signage. And the result really has been precisely what GCL Section 36.2 was created to avoid. The framers of this bill intended that it combat, quote, bad street layouts, congested living conditions, and blighted districts, and that's precisely what the BSA found. Now, because my time is limited, I want to very briefly point out that, again, there can be no practical difficulty or necessary hardship here. Petitioner did, in fact, submit alternative site plans showing very clearly that it could build 5 multiple dwelling buildings in 2 single-family homes as of right with access to mapped streets. That would be 252 combined units, or 83 units more than petitioner seeking permission to build through the waiver. And that's precisely because the land in question has approximately 1,030 feet of frontage on mapped streets. That's almost 3 football fields of frontage on mapped streets. So there really is no practical difficulty or unnecessary hardship in complying with the law here. If there are no further questions, we would ask that this court affirm.
Thank you very much.
Thank you.
The clear history of the statute, the general city law, is that it's a safety statute. And that's all it is. Is there safe access for emergency vehicles to the proposed developments? That's the way the law has been interpreted and applied.
That's not the language, though. You have to follow the text of the statute in determining. So we have to, or the BSA has to address whether there's practical difficulty, unnecessary hardship, and whether circumstances of the case do or do not require the structure to be related to existing or proposed streets. That is what the statute says should be considered by the BSA.
If the BSA was making that change to the, just rather than looking at ignoring court precedent about it being a public safety statute and going to the practical difficulty or necessary hardship, we are satisfied to rely on the practical difficulty standard. That even if you look at the theoretical as-of-right site plan that council just discussed, it still leaves 50%, it creates awkward buildings, it denies us access to 50% of our land, it creates a development that's completely out of character with the surrounding community. It still creates long driveways that we're not calling roads on the theoretical site plan, that the Department of Buildings will likely turn around and say, you know what, these driveways, or the fire department will turn around and say, these long driveways to the back of these new multiple dwellings are not driveways, they're really roads, and therefore we're not approving it. So the answer is, as a practical difficulty, the denial of access to 50% of our property and these awkward buildings out of character with this neighborhood all create practical difficulties. This is a unique site with almost 16 acres. To say that just building along the frontage and leaving all your entire half of your property vacant in the back doesn't create a practical difficulty is contrary to the long history of the law.
Thank you very much.
Thank you.
Justice Moulton is disqualified for the next case, Caban versus 1691 Fulton.
My adversary is not here, so I'm going to try to be quick, but there's some things I need to say. My name is David Tolchin for the plaintiff appellant Eliezer Caban. I'm a little disheartened that Judge Moulton just left. It's because he was on a panel last week that decided Rodriguez, which I filed with the court the other day.
I was a little confused about that site, though, because the whole reasoning of this case is that it's a ballast, and there's clear precedent that ballasts do not come under the labor law, but the case that you cited was not a ballast case, it was a smoke detector case.
Your Honor, I don't understand why a ballast is any different than, in order to...
But how can the smoke detector case overrule fairly well-established precedent about ballast?
To change this, Your Honor, to change the smoke detector, you have to do less than you'd have to do here to change out a ballast. And it wasn't just changing the ballast here. A ballast is a transformer. It has wires. It's connected to, hardwired to the lighting fixture. In order for the plaintiff here to have changed the ballast, he had to disassemble the fixture's cover, detach the wiring plate to reveal the internal wiring, sever and cap off the wires, unscrew the ballast with channel lock. He did this all on an 8-foot ladder. And he had to inspect the unit, realize that it couldn't be salvaged, search for a replacement ballast in a completely different building, bring it back and reinstall the new unit. And he did that by climbing up the ladder and screwing it in place with the power on, and then he got zapped. He could have, this...
You're saying we should overrule our prior precedent.
There's no prior precedent you're overruling. This is Picciano.
No cases about ballast?
Yeah, Picciano, Piccioni rather, I'm sorry. The plaintiff there was doing more than merely changing a light bulb like our client was. His repair consisted of replacing the ballast and sockets, disconnecting the wires.
The ballast and sockets.
Yes, Your Honor, we never got the opportunity here to see if we needed to replace the sockets because he got zapped before he had a chance to even try to replace the ballasts and then see what else was needed. But this was clearly more than changing a light bulb. We know this because he changed the light bulbs. That did not fix the problem. His boss said, "Can you please repair it?" And he went and attempted to repair it. That's not changing light bulbs. It is clearly more than changing light bulbs. The other cases that are precedential here, Rodriguez.
We're familiar with all the cases. Thank you very much.
Thank you, Your Honor.
The next case is Badzio versus East 68th Street.
May it please the court, Christy Kensig on behalf of Patrick D'Angelo and Ugia Jacobs. For convenience, I'm going to refer to them both as the Jacobs defendants. The Jacobs defendants' motion should have been granted because there's no basis for contractual indemnification, and the record establishes that the insurance provisions were complied with. First, focusing on the contractual indemnification issue.
Let me ask you, the language is pretty broad in terms of indemnification. It's arising out of language, which is basically the broadest type of indemnification there is. How should we not find that this arose out of the alteration work that was done in the apartment? That the only reason the scaffolding was there was to perform those alterations. So why didn't anything having to do with the scaffold arise out of the alteration work, which would thereby trigger the indemnification?
Sure, while the language is very broad, it is not limitless. And if
Sorry, what did you say?
It is broad language, but it's not limitless. And if we apply it to this situation, we're actually disregarding the language in the indemnification agreement that says it has to arise out of the work to their unit. Their work was completed a year before the scaffolding was taken down. The scaffolding was ultimately used for the 5th story Hunter's apartment, and the work in the Jacobs defendant's apartment.
The point that the plaintiff makes is that the scaffolding was put up in a way that didn't have enough places to hook off one's safety harness. And so that happened at the inception. And that's why your clients might be on the hook, or there's issues of triable fact about that.
So that's third-party plaintiff's claim in opposition on the appeal. That was never raised below to the court. There's no evidence that there were any defective conditions with the scaffolding. As far as that argument is concerned, it ignores the record that prior to plaintiff's accident, there had been an extra extension added on for the 5th floor work, and there had also been pieces of it dismantled prior to his accident. So there's nothing to show that the installation was negligent or that it was defective the way it was installed when it was installed for the Jacob defendant's apartment.
I mean, wouldn't it be more? Wouldn't your argument be more powerful? And I'm sorry if I'm rehashing some territory covered by Justice Kern, but if the indemnification clause stopped out arising out of the work, if it stopped there, I think you'd have a much stronger point. But then it goes on to say, or in any way related to. And here, this was, for lack of a better phrase, sort of a community scaffolding here for this project. The scaffolding was used in some way, shape, or form, in some manner, to affect the work for your client's premises, and the injury occurred on this scaffold. So isn't that last component of that last clause of the indemnification clause difficult for your position, the in any way related to language?
So again, no, because in order for it to be connected to it, the work had been completed for a year, and I believe I'd like to focus the court's attention. I believe it's Iman v. Binghamton, which had similar, it had the same language that it had to arise out of or be connected to the work, and there the Court of Appeals found that if you applied it where, again, that work had been completed And if you applied it, you are actually disregarding the portion that said it had to be connected to the work. Because again, here, the work had been completed for about a year prior to it. The scaffolding was then modified and extended to facilitate the Hunter's improvements and renovations, and was then had nothing else to do with the Jacobs defendants' renovations, because again, they'd been completed. I would like to quickly touch on the insurance issue. The record establishes that the third-party plaintiff's claims for damages based on failure to procure insurance should have been dismissed because all of the insurance provisions were complied with. The insurance provision required the contractor to obtain specific insurance.
Denial of the claim that there was a failure to procure insurance?
I'm sorry?
Was there an actual denial of the claim that there was a failure to procure insurance?
I believe, and correct me if I'm wrong, I believe what you're referencing is the court's reliance on the motion papers where it said basically there was an acknowledgement of the failure to procure it. I think that was a mistake on the lower court's part to read it in that way when it was really saying that the insurance provisions were complied with. However, even if they weren't complied with.
But did it say that they really were complied with, or did it just say we didn't have to comply with them?
I think it may have said that I think the actual phrase was the failure to procure insurance wouldn't.
So it never said we procured the insurance.
Right, it did not say they procured it
So
because
then why should the court have dismissed that claim if you didn't affirmatively state we procured the insurance?
Because there was no requirement for the homeowners to have the insurance. It was.
So you're going back to the first argument. Okay.
Sorry.
No, it's okay.
Okay, just based on the record, it shows that the insurance provisions were complied with, that the contractor did provide it, the building had it and acknowledged it. Thank you.
May it please the court, Glenn Kaminsky with the firm Omni Demersa Manis, counsel for the respondent appellant Sienna Construction. I'm going to address my arguments to the fact that Sienna is not a proper labor law defendant. And this is a fact-intensive issue, and I respect the fact that this court is well familiar with the record. So I'm going to just address myself to a few pages to make my argument clear. This issue essentially starts at page 575 of the record, where Mr. D'Angelo is clear that they are about to take down the scaffold that was built for the purposes of working on the fourth floor project.
Let me interrupt for a second, because it's clear that Sienna was the general contractor for one of the two projects for which the scaffold was installed, and it's clear that part of Sienna's obligations was the installation and the removal of scaffolding that was ultimately responsible for that. Under those circumstances, why isn't that sufficient to find that Sienna was a general contractor under the labor law?
Because what happened in this case is that there was intervening acts. There was this, when Mr. D'Angelo, a board member, realized that he was going to take it down, but that Hunter was going to need it.
But didn't
then
they
there was a
didn't
direction.
the contract clearly require that that was part of its contractual obligations, the removal of the scaffolding?
It was at the time, but they changed. Because it changed when Mr. D'Angelo made it very clear that we're going to take it down, but Hunter needs it, and the building didn't want extra anchors put in. They didn't want to go through the cost and expense of taking down, putting up another one, inconveniencing their residents. So what happened is Sagewood took over this scaffold. At a minimum, it's an issue of fact, because Sagewood paid for the extension. Sagewood paid for the monthly fees. Sagewood directed when it was going to be taken down. This, at the point of time, as counsel just indicated, where the fourth floor project was completed. They didn't need the scaffold anymore. This is an accommodation, a facilitation. At this point, we are just renting this scaffold to Sagewood, and we shouldn't be held as a labor law defendant under these facts. In a court that sits in law and equity, is it equitable to increase the cost to the parties, the inconvenience to the parties, when the parties simply want to transfer the scaffold to someone else. And giving my client every favorable inference, there's no reason to hold them in for summary judgment on 240, and in fact, summary judgment should have been granted to my client. The court relied below on Weber.
Thank you. You can respond on rebuttal.
Good morning, Your Honors. May it please the Court, Thomas Lehman, Woodsmith, Henning, and Berman, on behalf of Respondent Appellants Jeffrey and Marie Hunter. Your Honors, the plaintiff's accident did not arise out of the work that was being performed on my client's co-op unit, and accordingly, the indemnification claims against them should have been dismissed by the lower court. The Hunters and their contractor, Sagewood, did not engage plaintiff's employer to construct the scaffold in question. There's no dispute that Sagewood was no longer using the scaffold at the time of the accident.
Nobody was using the scaffold, huh?
No one was using the scaffold
It's
except
funny because both sides are making the same argument. I'm not responsible, you're not responsible, nobody's responsible.
I would submit that there's a slight wrinkle to that, Your Honor, that Sienia is the contractor that engaged plaintiff's employer. They were the only ones contracted with plaintiff's employer.
Right, but their argument is that they didn't even need it anymore. They were only accommodating your clients.
And if they were to have only accommodated my client, they could have asked them to assume the contract. They did not. They maintained the contract. They were the only ones who had a relationship with plaintiff's employer. There's no dispute that Sienia were the ones present on the day of the accident, supervising the scaffold's removal. My client's contractor was not there. They were not there. And all of the business between plaintiff's employer and the extension of the scaffold, was conducted through Sienia. If there are no further questions.
Thank you.
Thank you.
May it please the Court, good morning. Chad Shoquist for East 68th Tenants Corp. And its managing agent, Wallach. So the issue here is simple. Our shareholders, the fourth and fifth floor shareholders, are attempting to inject into these indemnification provisions a timeliness requirement, essentially that the agreement said that we only get indemnity if the accident happens during their respective projects, and that's not what the agreement says, as the court noted. It's a very broad provision. It includes language that we get indemnity for any claim arising from either of the projects, in connection with either of the projects, or in relation to either of the projects, and that's clearly the case here. The scaffold was initially installed by the fourth floor shareholders contractor for their project. The defect that plaintiff claims here, which is that he wasn't able to find a spot to attach his harness, was an original defect to the scaffold. And just to be clear, the plaintiff testified he was on the fifth level. There were originally 7 levels to the scaffold. They added 2 once they started the fifth floor project, but the plaintiff was on the 5th level when his accident occurred. That's his undisputed testimony. So this defect in this accident clearly related to the original installation of the scaffold for the 4th floor shareholders. And then obviously it was still up for the 5th floor shareholders when the accident occurred, and plaintiff testified, and this is undisputed, that he was in the process of dismantling the entire scaffold with his team from the 5th floor down. So any reasonable reading of these provisions and the facts in this case, which for our purposes are essentially undisputed, the indemnification provisions clearly apply, and the motion court was...
The insurance claim.
So we're not getting insurance. We haven't gotten insurance from anybody else. We've tendered to everybody in this case, and there were requirements in both alteration agreements that the shareholders ensure that we obtained additional insurance coverage from the other contractors, and we don't have any. So obviously, we weren't granted summary judgment on that. It's just a question of fact, but we haven't gotten insurance, so certainly there's a question of whether they breached that agreement, and the motion court was correct not to dismiss that claim for either of the shareholders.
Thank you.
Thank you, Your Honor.
May it please the court, Scott Heck from Gordon and Rees on behalf of Appellant Sagewood Construction. One of the arguments that was raised in appeal had to do with the court's granting of plaintiff's cross motion for summary judgment. And procedurally, the cross motion that was filed was not filed as to defendant's motion. So one of the initial arguments that we have in our paper is that the cross motion was procedurally deficient. We cited to the proper CPLR. In addition, Judge Kalish made it very clear at the compliance conference that any motions that were filed that were not in compliance with the CPLR would be immediately dismissed. So one of our arguments...
Want to address the merits?
We will certainly address the merits of the cross motion, and as we cited in our moving papers, the certification by Mr. Badzio was in conflict with the deposition testimony that he provided regarding how he fell, thereby creating an issue of fact based on his own testimony. Additionally, Sagewood argues that we are not a labor law defendant. I know the court has just recently heard arguments about that. We cite to our papers in terms of the fact that there was a supervisor there on site, not from our company, but more importantly, that the court, in making their decision to deny our summary judgment motion, relied upon the contract between Sagewood and the Hunters, and did not focus on the contract between Senia and InterSystems. Sagewood is not a party to that contract, and we made an argument as to privity.
Counsel, you concede that contractors can have concomitant or concurrent authority over a particular aspect of a job, correct?
Yes, Your Honor.
Aren't there at least issues of tribal fact concerning that with respect to Sagewood and Sienia?
And that's certainly why we raised as a secondary argument, Your Honor, that we were not on site, and there's specific deposition testimony from the super that says we are here to supervise the particular property. Thank you. Unless there are any other questions. Thank you for your time.
Thank you.
May it please the court, my name is George Ilkert. I'm here for the plaintiff, Thomas Badzio. The plaintiff suffered to fall 30 feet when he was not provided with any safety line or any other device to anchor his harness to, or the lanyard that was attached to it. He had to ascend the scaffold by constantly attaching and detaching and then reattaching his lanyard. Both Siena and Sagewood are proper defendants because they contracted for the work, the installation and the removal of the scaffolds. There are no outs for that. That is labor law, and that's why it results in absolute liability all of the time. Regarding procedural defects, the cross motion moves for summary judgment against all defendants, and the only thing I did was incorporate by reference the pleadings. I didn't see the need for a sixth set of pleadings in the motion papers. They were on notice of what the claims were and exactly how the accident happened with regards to both the 240 claim and the 241-6 claim. That's what I have.
Thank you very much. Any questions? Thank you. Okay, we're up to rebuttals now.
Thank you. Just again, contractual indemnification is improper here, despite the broad language in the indemnification agreement, where the work, again, as I said, had been completed. I just wanted to correct a couple of things that were stated. The Hunters did get a brand new proposal from InterSystems, and Siena, while Siena had been employed as the contractor for the Jacobs defendants renovations, Siena was not acting as the general contractor when it handled the scaffolding extension and rental for the Hunters project. The Jacobs defendants had no involvement once there was a new proposal, and then the Hunters exclusively paid for it, used it, and had control over when it was dismantled. When the Jacobs defendants completed their renovations in November of 2015, they received the sign-off from the plumber, the electrician, and the Department of Buildings. While they did not get the letter of completion from the Department of Building, that letter was tied into the removal of the scaffolding, but not tied into the renovation of their work. Finally, again, just addressing the insurance, the building's own witness did review all of the insurance documentation and testify that they received everything that they'd needed prior to the start of the work. If there are no further questions,
Thank you very much.
thank you.
In order to be granted summary judgment, plaintiff was obligated to prove that Sienna was a general contractor to make a prima facie case. And I argue, based on the facts of this case, that they failed in that burden. And even if they met that burden, we certainly raised sufficient testimony evidence to raise an issue of fact so that a jury can decide that issue. As to 240 itself, there are, again, as counsel indicated, there are issues of fact. To put before the jury the sole proximate cause of the plaintiff, where the plaintiff credibility as to what he did and where there is certainly a harness and a lanyard, and there's been no accidents on the site before, and he testified that he was able to do it in accordance with his OSHA training. I think there are issues of fact as to the sole proximate cause. An issue finding, as opposed to issue determination, is the role of the court, and I respectfully request its reversal of the decision. Thank you very much, Your Honors.
Thank you. We have one more rebuttal.
Just very briefly, Your Honors, we respectfully submit that the facts of this case are simply too far attenuated to warrant indemnification against my client, and therefore we request that the lower court's decision be reversed. Thank you.
Thank you very much. Winiarski versus Butler Jr.
May it please the court, I am James Halter from the law firm of Rasco Clock, Perez and Nieto, and I represent the plaintiff appellant, Stephen Winiarski. This is a case about Mr. Winiarski's employers making false statements to an important industry player and others that damaged Mr. Winiarski's career. The trial court erred in a motion to dismiss by finding that that was okay. That's not how defamation law works. The trial court found that because a month later, the defendants also fired my client.
Counsel, well, how can you get around the Murphy principle that there's no cause of action for wrongful discharge for at-will employees, and you can't create a cause of action by casting it in another light? As long as it's related to that wrongful discharge, it cannot be sustained as a viable cause of action.
I get it. That line of cases is not relevant here. That line of cases is about employee supervisor making a statement in a performance review or something that leads to a termination.
Is there any question that all of the complained of actions here have to do with the same event that was the basis for the ultimate discharge of the employee? How can you separate them out from each other? Aren't they intertwined in a way that can't really be separated?
I separate them out because the damage to my client is much more than a termination. My client cannot work at a company that services Target. There's a blacklist that Target maintains, that this is alleged in the complaint, a list of people that it will not work with, and that's defendant's statements, not the termination. Defendant's statements put that.
Why isn't that, going back to my initial question, why isn't that related to the reason for why they discharged him?
The law isn't about whether the statements are the same as the justification. The law, the Murphy, LaDuca, Larson, those are all about a causal chain that led to somebody being terminated. A coworker in Larson and LaDuca are both cases about nurses. A nurse said that person was insubordinate, and that led to them getting fired. That's an internal complaint by a coworker about them that resulted in their termination. That's not this case. Here, the decision makers were the ones making the statements.
But the plaintiffs in those other cases still were suing about the sequelae, the results of their termination. I mean,
they were not.
The nurse in LaDuca, was probably concerned that she couldn't get employment because she'd been she'd been fired. Why was she fired? Because she allegedly euthanized a patient. So are you saying that the information wouldn't come out in LaDuca, and therefore this is different somehow?
This is different. First of all, there's no facts at all alleged in LaDuca decision, anything that I've seen about LaDuca that says this is going to follow me, that you made this statement to somebody else, that this is now part of damage to my career or my reputation. The rule of law here is that employers, the trial court's rule of law is that employers are immune from defamation claims. That's just not the law. There's a federal court case, Osario versus Source Enterprises, Allen versus CH Energy Group. Those are both cases that went to trial in favor of jury verdicts in favor of a plaintiff.
Sir, are you familiar with our decision in McEntee versus Van Cleef?
I am.
Okay, how would you distinguish this case from McEntee?
So McEntee versus McCleef was a jewelry salesman who got fired. His supervisor made a complaint about him and he got fired. There's no statements at all outside of the company in McEntee versus Van Cleef. His complaint was, his tortious interference complaint was, well, now I can no longer service those clients, those customers of the jewelry business. That's very different from this case. This case is my job, my client can't get a job. This case is, every defamation per se case deals with damage to somebody's career and reputation. That's what this is. The damage here is the amount of time that my client spent unemployed because of the statements versus not because of the statements. That's not a damage that exists because he was fired, that's a damage that exists to his career, to his reputation. He would have spent less time unemployed if not for these statements to Target. His job now, he did eventually get a job, is a much lower quality job because he can't work at a place that services Target. He's been calling on his Target clients, Target contacts, they don't call him back. That is because of their statements to Target. If he had just fired him, that wouldn't have been the impact. This wouldn't be following him around. That's what we're trying to remedy here. So the difference between those cases, that line of cases, Murphy, and the case here, is the statements were made externally by the decision makers. This wasn't an influence on the decision makers to eventually terminate the person. The defendants here were the decision makers. It's his boss, it's the owner of the company, it's the company itself. The defendants try to make much about the allegations that complain about scapegoating, but that's completely consistent with a viable defamation claim and a viable tortious interference claim. Tortious interference requires intent and knowledge, intent and malice. The complaint alleges they knew this was false. They knew that they were selling something to Target that was not true. Matter of fact, they knew they were telling Target something that was going to end up with my client on their blacklist, that he was no longer going to be able to service Target customers anymore.
Thank you. You have a chance for rebuttal.
May it please the court, Francis J. Giambalvo from Gordon Reese, Scully, Manson County, on behalf of the respondents. Your Honors, the well-reasoned six-page opinion of the trial court dismissing appellant's defamation and tortious interference claims as nothing more than impermissible wrongful termination claims should be affirmed. The same cases, the same central points raised in the decision below are once again at issue before this court. An appellant has not provided this court with a single case that is contrary to the holding below. Instead, appellant simply tries to distinguish the cases that unequivocally support dismissal of the complaint, which, as the trial court astutely pointed out, amounts to an exercise in distinction without a difference. As Your Honors pointed out in Murphy, it's well settled that New York does not recognize a cause of action for wrongful termination of an at-will employee. It's also well settled that tort causes of action, such as defamation and tortious interference with business relations, cannot be used as a means to bootstrap or bypass an impermissible wrongful termination claim. And courts consistently apply the at-will doctrine in dismissing tort claims by finding that such claims were actually impermissible wrongful termination claims or a surrogate for a wrongful termination claim.
Well, your friend is saying that I'm not worried about wrongful termination. I'm not working there anymore. I'm looking a bridge further, which is now my reputation to third parties has been irreparably damaged, at least to a significant former client. And so that's what takes my case out of the Murphy line. And what's your reaction to that?
Sure, Your Honor. So I think, as Your Honors pointed out earlier, the key inquiry here is whether or not the alleged tortious conduct is so closely related to the termination that it cannot stand as a distinct cause of action. And that's exactly what happened here. And the factual allegations are consistent with those in LaDuke, in Larson, in Brooks, where false statements were made that ultimately resulted in the employee's termination. And each of those courts dismissed the tort-based causes of actions pled therein as impermissible substitutes for the impermissible wrongful termination claim. In this case, the gravamen of the allegations in the complaint, which are taken as true for purposes of a 32A11-7 motion, is that appellant was an exemplary employee of Schmetti Construction Company until he was terminated as a false scapegoat and defamed and terminated without cause. Defamed and terminated without cause. By appellant's own allegations in the complaint, there is no distinction or separation between the alleged defamation and the alleged wrongful termination. For that reason alone, the lower court's decision should be affirmed and the case should be dismissed. The appellant essentially alleges that he engaged in a buyout procedure with one of Schmetti Construction's clients, Target. Target then confronted Schmetti about this alleged prohibited practice, and then Schmetti told Target in response that appellant was not authorized to do the buyout, that was statement one, and that he acted as a rogue project manager. In turn, he was terminated for such conduct. And so essentially, appellant alleges that Schmetti, his employer, made him a scapegoat by first falsely stating that appellant engaged in the unauthorized buyout, and then terminating him based on that same fabricated charge. Moreover, the fact that appellant alleges he was deliberately made a scapegoat to help cover up wrongdoing by the respondents only serves to underscore that the alleged acts of the respondents are, again, too closely related to the alleged wrongful termination to stand as any distinct causes of action, which is consistent with the appellant division's holdings in McEntee, LaDuke, Larson, and I thank you for your time.
Thank you very much.
The distinction here is, okay, fire him. You've got the right to fire him. You can't stop him from getting another job. That's something they intentionally did here. The weird fact pattern that they want endorsed is there was a viable claim for a month. They made the statements to Target in December of 2019. They fire him a month later. They fire him after I sent a letter that said, hey, let's try to resolve this. That claim existed for a month, and then they say it went away because we fired him. That's not how... There's no immunity for at-will employment. You can't damage somebody going forward. He keeps saying it's too closely related. It's too closely related. The statements to Target are irrelevant to the termination. You can terminate him for any reason that you want. You don't get to kick him on his way out the door. And that's what they did here.
Well, maybe you get to kick him on the way out the door, but not once he's out the door.
Fair enough. Fair, Your Honor. The analogy I'm using is a poor one. Yes, you do get to kick him out the door, but you don't get to put a sign on his back that says, kick me some more.
Sir, what's the strongest precedent in your view that supports your claim here, that takes this case out of the Murphy line?
Allen versus CH Energy, it's 5883rd 1102. It's a defamation case. I'm sorry, may I finish?
You can finish answering this question.
It's a case about a coworker made a statement about another coworker that he's defecating in the parking lot, and that was a viable defamation claim that went to trial and resulted in the plaintiff's verdict. His coworker's statements, he was shortly terminated thereafter, about some sort of medical issue, sort of related to defecating in the parking lot, but it's a viable case of defamation because even though it was a coworker saying it about another coworker, the statements impacted his career and reputation going forward.
Thank you very much. No, you can't respond. Cavalino Consulting versus Steiker Corp.
Good morning, Your Honors. May it please the Court, my name is David Piedra, and I represent the appellant relator Cavalino Consulting. My client commenced this action under the False Claims Act to address an ongoing scheme by defendant Stryker Corporation, which has overcharged New York State hospitals, millions of dollars. The court below dismissed Cavalino's complaint with prejudice on a pre-answer motion, and I respectfully submit that the court below erred. The order below should be reversed, the complaint reinstated, or at a minimum, Cavalino should be given an opportunity to replead to address any deficiencies in the complaint.
Let me ask you a question. If the contract provision regarding shipping costs is ambiguous, doesn't that mean that the case has to be dismissed, since it would not be enough to show scienter? The only way you can win is if the contract clearly provides that you have to charge actual cost versus list price?
Well, I disagree, Your Honor. I think that if the contract is ambiguous, it should be determined by the court.
And it's susceptible to different interpretations, then how can you show the falsity of it where reasonable minds could differ?
Well, I don't agree with the premise that reasonable minds could differ on this particular
Well, if it's
clause.
ambiguous, doesn't that mean reasonable? I'm using those statements somewhat interchangeably, which I think the law does under the False Claims Act in terms of analyzing these type of cases.
But the contract here is not ambiguous with respect to shipping costs because it defines what shipping costs are as the amount that Stryker must prepay.
Does it anywhere say that they must charge the actual shipping costs versus the list price shipping costs?
Well, it doesn't use the word actual, but in all honesty, Your Honor, that is a superfluous word. The contract defines that shipping costs are an amount that is prepaid. In the same sentence, it says, but you can charge those shipping costs, the shipping costs that you have prepaid, if you list it on the invoice. It doesn't say you can charge any shipping cost. Actual would be completely superfluous. And in reality, that's not the way business contracts are written. Actual is a word that doesn't add anything in this instance because the contract defines shipping costs. If at the end of the day, a contract says, the price for this good is X dollars, and it comes to time to transaction, I said, well, I didn't say actual price. The actual price is different than the price. Of course, you would consider that absurd.
What significance should we give, if any, to the fact that the state has chosen not to intervene in this action?
Well, in my view, you should give no significance to that. At the end of the day, there's no requirement, certainly in the FCA, that the state must intervene. The state is entitled to make their own judgments as to the deployment of their resources. Their resources are limited. The FCA was created so that private individuals could pursue claims when the state couldn't, either because it was financially not advantageous.
How about the hospitals that comprise med assets? They have not sued Stryker, have they?
No, the hospitals have not ultimately commenced any action. But again, that's not a question here for the court to determine on a motion to dismiss. The allegation is that Stryker knowingly violated this clause, has done it in other cases, and knows that it's supposed to pass along only its shipping costs that it actually prepaid and failed to do so here. If it's knowing, if it's material, and deliberate, as alleged, the complaint should be reinstated and the action permitted to go forward. Ultimately, Stryker can argue later that either the contract is ambiguous or that there's a lack of scienter.
Let me go back to the original question, which is, if it's not clear from the face of the contract that it has to be actual, does that follow then that there is not sufficient scienter to support a False Claims Act?
Well, here it is pled that there is sufficient scienter because there have been...
We shouldn't actually look at the clause and make our own judgment. It's a contract.
Correct.
Which the courts are allowed to make determinations in their face as to whether they're ambiguous, non-ambiguous. I mean, we're actually required to in contract cases to make that determination all the time.
But if it's ambiguous, that leaves an issue of fact to be determined by a trier of fact as to whether there was scienter, whether they knew.
If the contract is ambiguous such that, which would mean you couldn't win in a summary judgment motion, how can it be sufficient to establish falsity?
Because at the end of the day, we assert that the contract is not ambiguous, and it isn't. It can't be read the way that they espouse, because it would allow them to charge any amount, an infinite amount for shipping, and certainly that's not what the state was asking for in the contract.
They didn't charge any amount. They charged the listed cost, correct?
Yes, they charged the list.
I'm sorry, let me just finish the point.
Oh, sure.
They charged costs that were known to your client.
They charged costs that were listed on an invoice.
Right.
But not what they actually incurred in shipping.
Sure, I understand that, but the issue here, as I understand it, is you believe they should have passed along the discount and not charged what was otherwise a lawful cost for shipping. They should have saved the money in that sense. They got the discount, and your client paid an otherwise lawful shipping costs. That's your position.
Well, but it isn't lawful, Your Honor, if it's knowingly more than the state agreed to pay in the contract, which was that they would get the benefit of these discounts, that the shipping costs would be prepaid. It's only the amount that they prepaid, whatever that may be, that they can pass along. It's in the same sentence, prepay shipping costs and pass along the shipping costs. It can't mean two different things in the same sentence.
Are there any more questions from the
If
bench?
there's nothing further, thank you.
May it please the court, Your Honors, Daniel Weinberger for Stryker Corporation and Stryker Sales Corporation, now Stryker Sales LLC. Since 2015, Cavalino has consistently sought to shoehorn a groundless, run-of-the-mill breach of contract claim into a cause of action under the False Claims Act.
Can I just ask you a question? The shipping cost that is charged, is that a cost that is regularly charged by the shipping carrier? I mean,
Yes, that's what they've alleged, yes. And there are actually several cases that Cavalino has brought against other medical equipment suppliers, including Medtronic and Smith & Nephew, where they brought the same claims. They said that under their contracts, they were supposed to charge only their actual cost of shipping. They brought claims in federal court in Massachusetts and Minnesota. Those claims were dismissed, just like the motion court dismissed this claim. If Med Assets had wanted to require Stryker to charge only its, quote, actual costs of expedited shipping, it certainly could have come up with clear language to say that. It was made up of, the Med Assets group was made up of experienced professionals who were brought together to come up with contract terms. They didn't do that, and Stryker cannot be held liable, least of all under the False Claims Act, for not reading an unwritten, implied contractual requirement into these contracts, especially when only Cavalino seems to be the ones that divine that interpretation of the contract.
Well, sir, let's say that we go back after argument and we talk this case over, and three of us read this interpretation, this clause, this shipping cost clause one way, and two of us read it the other, and therefore, well, we're fairly reasonable people. It's ambiguous. Should the 3211 motion be denied, as your friend suggested, and allow the record to be developed?
No, not at all. First of all, I would say that the question of ambiguity is a question of law to be decided by the court on a motion.
And so we find as a matter of law, this is ambiguous. And now what flows from that in the context
then the case
of
should
this
be dismissed
quietam?
because the provision is ambiguous. The court cannot find or cannot be found that Stryker had the requisite scienter to commit a violation of the False Claims Act. If this were a breach of contract case brought by Med Assets, maybe that would result in a different story. But this is a False Claims Act case, and they cannot bring a False Claims Act case based upon an imprecise, ambiguous provision. We believe that the provision is unambiguous in the sense that it does not require Stryker to charge its, quote, actual cost of shipping. But even if it were ambiguous, that would not create a cause of action under the False Claims Act. In addition, the complaint also fails to plead materiality. The motion court didn't need to address this issue, but under Supreme Court precedent, United States Supreme Court precedent, these alleged overcharges are not material to the contracts at issue.
We agree that there is no scienter. Do we need to address materiality?
I'm sorry, I couldn't hear.
If we agree, if we ultimately agree that there is no sufficient allegation of scienter, do we need to get to the issue of materiality?
Not at all, not at all. And if the court would like me to address scienter more, I certainly can do so.
No, I'm just asking the question.
No, it's just an additional element that also must be pled that they also failed to plead and cannot plead. Under Supreme Court precedent, the court had asked whether Med Assets brought a breach of contract claim, and counsel acknowledged no, they did not. The state of New York twice declined to intervene, once in a federal action that was brought in 2015 and amended in 2017, and again here. And some of these contracts, the terms of them did not expire until 2018, after even this action was brought. So the state hospitals, the state, knew of these allegations, and they still paid the charges. So they made the decision. Their actual behavior shows that it was not material.
Counsel, just to clarify one minor point, all those other actions you referred to where your adversary was unsuccessful in being able to recapture the monies, were they all under the False Claims Act in all those jurisdictions, or were they breach of contract actions?
They were all False Claims Act in
all false
other jurisdictions. If the court would allow, I would submit the citations for those cases, if permissible. And just to conclude, unless the court has additional questions, I do want to quote from one federal appeals court that I believe is directly on point here. It says, "An FCA relator cannot base a fraud claim on nothing more than his own interpretation of an imprecise contractual provision. To hold otherwise would render meaningless the fundamental distinction between actions for fraud and breach of contract." Yet that's exactly what Cavalino has sought to do here. The motion court correctly recognized Cavalino's claims for what they were, and it dismissed them with prejudice. The court should affirm its judgment.
Thank you very much.
Thank you.
Very briefly, on the issue of other cases that Cavalino Consulting has filed, that's not in the record, and they're different contracts and different agreements that are at issue, not necessarily, or regulatory schemes that are at issue, not necessarily the same here, so it's not apples to apples. In terms of the contract itself, just to turn back to the language, Stryker must ship the product and prepay all shipping costs and may charge the shipping costs if listed as a separate line. Shipping costs used as what they prepay and shipping costs in the same sentence used as what they are allowed to charge has to mean something. It's not ambiguous, I respectfully submit, and it's not susceptible to their interpretation. If there's no further questions, I'll submit. Thank you for your time.
Thank you very much. Schultz versus Cambridge Development.
May it please the court, my name is Joseph Lessem of the law firm of Gravard Miller, attorneys for appellants. I'm not going to reiterate the arguments in my brief, there's no adversary here. I just want to make one point. In its brief in opposition, its respondent's brief, respondent's counsel talks about deplorable conditions, that's her term, rendering the apartments uninhabitable. Leave aside the fact that there's no evidence presented whatsoever. If there were any truth If in fact there were any deplorable conditions, one would think that the plaintiffs in this action would want to move this case to trial as quickly as possible. Instead, the 12-year history of this case is that repeatedly the plaintiffs refused to provide discovery, forcing motions to compel, which they repeatedly adjourned. In one case, 11 times. When we made the motion for summary judgment, they got 6 months worth of adjournments. When we promptly brought this appeal, they got it adjourned again to the November term. Plaintiffs' own actions belie their claim of deplorable conditions. Other than that, Your Honor, I'd simply ask that the judgment of the court be reversed and that all claims be dismissed.
Thank you very much. Community Association versus Butts.
May it please the court, Jared Mogul, the law firm Gordon Reese Scully Manzacani, representing defendant appellants Abyssinian Development Corporation, Dr. Reverend Calvin O. Butts III, and James Howard. Good morning, Your Honors. This matter concerns the hindsight scrutiny of the 2014 sale of a commercial property. Appellee's complaint suffers from several distinct pleading failures, which could not and cannot be overcome. However, the crux of the dispute on appeal is what constitutes ample facts to support an inference of fraud. The thrust of appellee's claim rests upon the existence of such a vast and complex fraudulent conspiracy with the inclusion of each and every named defendant across 3 separate entities. Yet nowhere on the face of the complaint is such conspiracy supported. So looking at the facts of the complaint, we're really left with three non-conclusory factual underpinnings. First being after a purchase offer of $39 million was accepted, that sale was ultimately consummated, the broker defendants received an offer from People's Integrated for $42 million. That's the first allegation. Then upon an information and belief as it's pled, the brokers relayed that offer to my clients and the lawyer for my clients, Mr. Simpson. Then we're looking at the third actual allegation, are 2 board meetings. The first on March 24th, 2014, that an unidentified board member asked if there were any other offers to purchase that property, at which time the lawyer for our clients responded no. A week later, a second board meeting.
And why isn't that false? I'm not sure why this is so complicated. I mean, I know there are a lot of players and moving parts, but the actual allegations are fairly simple. That there was an offer for $42 million that was never conveyed, there was an actual lie about it, and that all of the defendants who the fraud claim was asserted against were aware of the actual price and the offer for a higher amount, was aware that it was never conveyed to the board, and therefore there's a claim for fraud. What is wrong with that analysis?
Because it requires a reasonable inference of circumstances of fraud. It could just be if it's a misrepresentation, which not conceding that it was a misrepresentation, but if it was, it has to be with the intent to defraud, which is not pled at all.
If you, as a person, know there's an offer outstanding for $3 million more, and that's not conveyed to the board, and you know that's not being conveyed to the board, how is that not participating in the fraud? I'm not sure what you're arguing, to be quite honest, exactly.
Because
they didn't know, or that the fact that they knew and they knew the board knew something different doesn't make out a fraud claim?
Well, so I think the first of the easier analysis really relates to my client, Reverend Calvin O. Butts, who wasn't at either of those meetings. So to the extent that...
Wasn't he Howard's supervisor?
Right, but he also did not necessarily attend those meetings and know what Howard relayed. So you'd have to presume that there was a conversation after the fact, which is not pled, that would say that Howard reported, oh, right, that offer that was on the table, we didn't convey it. which is not alleged at all in this complaint. So to the extent that, it's one thing for the Reverend to understand and know that there's another offer.
Isn't there an allegation in the complaint, though, that Butts was the chairman of the ADC, he was the supervisor of Howard, who did attend the meetings, and he took an active role with Howard in managing the sale, that the offer was sent directly to him, so he clearly knew about the higher offer. Why aren't all those allegations sufficient to make out an aiding and abetting claim against him?
Because it's not simply enough to say that the offer was known. He had to also know that there was a misrepresentation, which him not being at those meetings to be present for those misrepresentations, again, not considered.
You're saying there can't be a fraud claim against him or an aiding and abetting claim without him actually being present at the meetings and hearing it being said himself. If he knew that it was said, which I think it's alleged that he knew what was said, that wouldn't be enough to make it a fraud claim?
Well, because it's a conclusion that he knew what was said. It's not based on any knowledge of any conversations afterwards. There's no actual allegation that...
What's the significance, if any, of the advance that was returned, the advance of $2.5 million from Extel to ADC? Is there any significance to that?
No, Your Honor, and it's not in the record, it's not in the scope of this appeal, but that was the practice of fielding offers. That was what was done with any serious offer that was fielded, was that a deposit was retained. And at that point, the return of that deposit was strictly to appease plaintiffs and appellees in their clear concern that something was amiss here, which there is no amiss here. There is no there.
Sir, doesn't Pluteman, the Court of Appeals decision in Pluteman versus Northern Leasing, counsel against granting a motion to dismiss where the allegation is fraud and the fraud involves an organization and individuals, where there may be there's a concern that the information needed to frame a more precise pleading is exclusively in the knowledge of the alleged fraudsters?
Well, actually, Pluteman is an excellent example of how this case differs from the allegations that were made in Pluteman. We're talking about in Pluteman a systematic and national scale fraud where, yes, the individual defendants were not released or dismissed in that action, but because it was shown that they were involved in every step of the organizational structure. We're talking about two conversations that occurred at a board meeting.
But isn't that exactly what's alleged here, that Butts was involved in all aspects of this sale and that he was sharing information at all times with Howard about all aspects of the sale?
But the allegations in Pluteman were that there was a widespread fraud over a long-term system of corporate acts. We're talking about one action here, which was the sale of the property, and the actual fraudulent conduct that's being alleged here has no bearing, has no connection to Reverend Butts. He was not present for those conversations.
You're saying because he was not present, I'm repeating my question, but he was not present, he didn't have any knowledge that false information was being conveyed at the board meeting.
That's our position, Your Honor.
Yeah.
So, appellees also rely on, I think to their detriment, Bernstein v. Kelso, which really highlights the differences in the pleading of fraud versus what we have in this instant action, where in that allegation you had situations where corporate actors had a clear incentive to reduce the value of share prices. Where here,
I'm going to let you finish up with that thought in your rebuttal since you have rebuttal time.
So the idea is that there
on
was...
rebuttal. I'm going to
on rebuttal, I understand.
Since you have 2 minutes of rebuttal.
Good morning, Your Honors. May it please the Court, David Wolf from the law firm Landy Wolf for the appellants Victor Sozio and Ariel Property Advisors. They're the real estate brokers. And this appeal presents an interesting question of what duties does a real estate broker have? Here, it's alleged that the real estate brokers kept their primary contacts fully apprised of all offers, including the Peebles offer, and that those two primary contacts are the two people who took the lead role in managing the sale of the property. There's no allegation that the brokers made any misrepresentations. Rather, the allegation is that they failed to stand up and interrupt the board meeting and say,
You don't think as brokers they had some, it's clearly alleged that they knew about the offer for a higher price. They were present at the board meeting where the false statement was made that there was no higher offer, and they stood silently by while the people of the board meeting were not told. You don't think that is enough to plead a breach of a fiduciary duty on the part of the brokers to all the people who are purchasing? Clearly, there was more than one seller in this case, and they clearly were part of the group that was selling the property. You don't think that's a breach, alleged?
So it's been alleged that they breached their fiduciary duty and that they committed a fraud in that manner. Now, the breach of fiduciary duty claims are all time barred unless there
That's
is
the fraud, which
unless there's a
clearly an
viable.
allegation that it's tied in with the fraud of not disclosing that there was a higher priced offer.
Right, so to work back to get to the right outcome here, you need to see, is there a fraud? For there to be a fraud based on failure to correct a misrepresentation, there has to be an intent to commit fraud. Now, they don't even allege that in their complaint. Plus, it would just be nonsensical because these are commissioned brokers. They make more money when the sale price is higher. That's the reason they spent a year soliciting offers. That's why they solicited the Peebles offer. That's why they communicated that offer to the ADC defendants. Their duty
Was
isn't
that argument
to...
raised below? Not that,
I'm sorry?
apart from the merits, was that argument actually
Yes.
raised below?
Yes, it
The
was.
trial court?
I'm sorry?
Was that argument raised before the trial court? that there was no
100% yes, it
financial
was, Your
motive?
Honor. It was raised below, and it's in the pleadings itself that that it's alleged that they kept those two board members fully apprised. If you're asking...
No, my question is, was it argued below that they had no financial motive to defraud? That was my question.
Oh, the lack of intent, we raised that on this appeal, which is...
Did you raise it below?
We didn't raise it below. That's new cases that we're citing here, which is apparent from the face of the complaint, so it can be considered here. And we cite authority for that effect in our briefs, which they don't challenge in theirs. But ultimately...
Well, there's no reason to throw, march out a parade of horribles about what could happen in a situation like this. But this is a pleadings motion, and the fact that on the surface, the brokers may not have a financial motive, that's more of a merits question, right? We're confined to really the...
Well, they need to say something about why it would make sense for this to be a case. You can't just say there's a conspiracy and that's the end of the story. Well, they've pled it, so it exists. Even on a 3211 motion, it has to make sense.
But how would they know, if they're strangers to or not parties to the alleged conspiracy, how would they have that information and able to be in a position to plead it? This goes back to Pluteman versus Northern Leasing, of the intricacies of an alleged fraud normally are not in possession of the plaintiff pleader.
Well, if you don't have evidence of a fraud, you shouldn't sue people for fraud. And again, we're talking about real estate brokers.
Why doesn't this work both ways, though? If they obviously knew there was a higher offer, knew there was a lie being stated, why did they have to have some motive to not speak up in that situation? Whatever that motive was, which we don't know at this point, we don't know what their motive was, but they clearly stood silent when they heard a lie being told to people who they knew were part of the selling group. So we don't know what that motive was, but they didn't say anything.
Well, then let's move on to the question of, do they allege any compensable damages? And they clearly don't. They're alleging that, but for this misrepresentation, they would have sold it to Peebles. That's purely speculative. It's purely...
Why is it speculative under these circumstances? Because there was a pretty definitive term sheet offer from Peebles. This wasn't just a speculative, is there, an offer floating around out there? It was very definitive.
Well, first of all, for 100 years, the courts of the state of New York have said you get no elements of profit, and there's case law that we cite where even when it's non-speculative based on fraud, you still don't get additional profit. And that's squarely what they're looking at. I would address the court to the pre-lawsuit letters that they sent asking as a prelude to bringing a derivative claim, where they said, bring this action to recover the additional profit that we could have found had we sold. That's in record 231 and 232. That's precisely what they're trying to do. They're trying to get additional profit. They're not trying to recover a loss. Now, that's a really critical...
Oh, there's no fraud claim if they say we were underpaid?
Well, they don't say that they were underpaid. They say that we could sell for a greater profit. And in case after case, Norcast, which I believe was a 3211 decision, where this court affirmed, if I could just finish, this court affirmed the dismissal on the 3211 motion for failure to plead an out-of-pocket loss where it was alleged that they sold the assets for too little. And same thing in the Sardonis. These are squarely on point. They're trying to recover profit, not an out-of-pocket loss.
Thank you, and you'll have more chance on rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court, my name is Reginald Richter. I appear for the Community Association of the East Harlem Triangle, who is suing derivatively on behalf of the EHAD Corporation. Bernstein V Kelso is cited by the lower court, is directly analogous to this case. In Bernstein V Kelso, the strikingly similar case, the court found that where there is a fraudulent scheme to sell a corporate stock below its value, then out-of-pocket
Counsel,
damages.
in Bernstein, weren't there more facts, at least in the decision of Bernstein, that showed what impelled the board members to do what they did? Here it's kind of a mystery. The defendants say, why would we do that? Because we're losing money too. And so they call it a vast, inexplicable conspiracy because they're going to lose money if they are conspiring to do what you say that they were going to do. Whereas in Bernstein, there was like a profit that was shown to go to the board members by underselling the property.
Well, first of all, I think there are two different things. When you talk about whether this particular damages are sufficient, where there's an asset is sold below its value, that's what the proposition that Bernstein Kelso stands for. And that is clear, and that's exactly what we're alleging here. It's not true that we haven't pleaded value. This whole process, this is a process designed to arrive at the value of the asset. When we do a process, we go to market, we sell it, the broker informs the board of all the offers, and it's a cash. This is a cash transaction. So it's designed to arrive at the value. And here, when they didn't disclose the higher offers, it obviously, the inference from that is it did not achieve its fair market value. And in the ad damnum clause, where you want to look when you want to know what the damages are alleged, you don't look in the middle of the narrative. You look at the ad damnum clause, and what do they claim their damages? We clearly state that we are suing for the difference in the value and versus what it was sold for. Now, on the issue of, well, why? Why did we do it? They keep bringing this up. Why did we do it? What was our motive? How could we possibly do it? Pluderman and Ubiquint, in that line of cases, Jarrett Construction, make very clear that it is an injustice. It would be an injustice to dismiss a case on the grounds that there's information where the defendants can only know their rationale. Only they know if they did a side deal. Only they can know if there were other incentives for them to do it. We can't plead that. We can't know it. And the only way we can know it is with discovery. And guess what? We can't get to discovery if you dismiss the case now. But we could, in discovery, have a letter from Extel saying, look, let's work this out. I got another way I'll make you whole. And it would be an injustice not to let this case proceed when that's out there. These allegations are very clear. Their motivation, you do not have to prove the motive of the fraud, the party committing fraud. You have to prove that he knew the lie. And here, each one of these defendants had a duty. They not only knew about the higher offer, they knew that the guy with the higher offer was willing to go even higher to match a higher, if his was not the highest offer. None of them, even though they had a duty, none of them disclosed it. The broker stands in a meeting next to the lawyer, and there's a lie told. He has a duty to correct it. He never does.
Sir, what about your friend's point that Reverend Dr. Butts, there's no allegations specifically directed against him in the complaint? So he's named in the caption, he's identified as a party, but there's no even allegations, let alone whether there's truth to them, but there are no allegations asserted directly against him.
How would we know what Butts does in the conspiracy? In the holding in Pluderman, as you pointed out earlier, is that you only need to plead rational facts from which could rationally be inferred that he had knowledge. And here, the fact that Butts is the most senior-most person involved in this transaction. He's Howard's boss. He knew about the offer. He received the offer. He knew they were willing to go higher. And when he wasn't at the meetings, but he voted for the sale at 39 million. And at no point did Butts meet his obligation and duty to disclose the offer. And as a board member, isn't his obligation to try to maximize the price? How can you say they had a motive? They even argued they had a motive to maximize price. Well, if you're that's directly counter to the inferences from the complaint, which says they knew about the higher offer and they didn't reveal it. You're showing that you don't want to maximize the price. You want to steer it to a favored buyer. Why that is, we can't know. But you know what? In discovery, we could find that letter, that email, that would give insight to that. But what they're asking is that we don't even have that opportunity.
Thank you.
Thank you, Your Honor.
So if I may, I would like to return to Bernstein v. Kelso. To answer Justice Moulton's question, there was actually incentive pled in that complaint, which was that the defendants, the individual defendants, had shareholder rights that were only exercisable with a drop in value of the shares. That's a clear incentive. That's noticeably absent from this case. There's certainly no reason, and it strains all credulity to think that you can just say there's a vast conspiracy without showing anything. We're not saying that all unassailable proof needs to be brought into the pleadings, but something, some fact that would explain why these defendants would all coordinate and coerce themselves to a lower sales price. It also ignores the very distinct distinction of, say, a stock value, a candy bar, a magazine. Selling real property isn't the same as those sort of sales. There are reasonable reasons to pursue a lower offer that's completely ignored by appellees in this case. You have due diligence requirements, you have speed of closing, you have lots of reasons why it makes sense to take a slightly less offer, and it has no bearing on, it has no fraudulent motive whatsoever.
But the issue here is that the rest of the board members were not informed that there was a higher offer that was kept from them. And they asked specifically, is the $39 million offer the only one? And no one said that there was a higher offer.
And so if
isn't that the issue?
So the issue is, if there was a material misrepresentation, which we're accepting as truth for the purposes of reviewing the pleadings, fine. But then there's also a second part of it that is the scienter, that is the motive to commit fraud, and that's noticeably absent. So it could be a misrepresentation, but it doesn't necessarily make it fraud. And so while I still have a brief moment, I would like to discuss some.
You actually don't have a brief moment.
I don't have a brief moment.
Thank you.
I didn't earlier have a chance to complete an answer to a question that Justice Kern asked, which is why is this speculative? And the reason it's speculative is that the plaintiffs are assuming that had the existence of the Peebles offer been disclosed at that March 24th board meeting, then the board would have preferred that offer, would have signed a contract, would have closed, and they would have made that additional profit. There's so many steps between offer and closing that it's completely unreasonable to assume that it's a concrete offer as the lower court described it. A term sheet, which is what we have. We don't have an offer. A real estate offer is something different than a term sheet. An offer is something I say, I'll give you this, and if you say yes, boom, we have a binding contract. In real estate, we do not have that. So in real estate, we have a term sheet, which is basically meaningless, and we have so many steps between term sheet and closing that you'd have to speculate that it would have closed. You also would have to speculate that the board would have preferred that offer. And they can't do that because one of the board members who voted in favor of the Extel closing died shortly after the board meeting. And to win, the plaintiff would have to prove somehow that this deceased person who isn't there to speak for herself would have changed her mind and would have done something differently. They can't do that. That's pure speculation, and it's unprovable.
So aren't these very powerful arguments for summary judgment?
They're powerful arguments for a 3211 motion because there's no damages, and the only theory they have is pure conjecture and speculation. Even on 3211 motion, they're not allowed to just say, well, maybe this could have happened. It wouldn't have. There's no way to know or not know whether it would have happened, and that's why this court has on 3211 motions repeatedly affirmed the dismissal of claims where there's no out-of-pocket loss. They're trying to prove that they could have made more of a profit. If I could very briefly.
No, but that's good. Happy Thanksgiving. Thank you very much.
Thank you.
Foley versus O'Neill.
Good morning. May it please the court. Christopher Ranke, counsel for petitioner appellant Matthew Foley. This case is about a long-tenured and distinguished sergeant of the New York City Police Department who was summarily terminated, and the termination was so draconian and disproportionate to his alleged and unsubstantiated conduct as to shock one's sense of fairness, and therefore constitutes, among other things, an abuse of discretion as a matter of law. Among other things, both the NYPD, as the administrative agency, as well as the lower court below, failed to consider a myriad of things that they should have considered as provided for in the Court of Appeals decision of Appellate. They didn't look at Sergeant Foley's length of employment, devotion to the NYPD, how highly decorated he was, the probability that the dismissal has left him with, quite frankly, a lack of alternative livelihood in terms of a future in law enforcement, including in private security, his loss of retirement benefits, the effects on his innocent family, and the fact, perhaps most importantly, that this case is void of any conduct, including even alleged conduct, of grave moral turpitude, grave injury to the agency or to the public weal, any deliberate, planned, unmitigated larceny.
Some of the conduct's not, I thought it was admitted by you that, for example, that he did not dispute that he called in sick only after being contacted by PBI. You're not disputing that, are you?
I'm not disputing the precise timeline of events, but what I would suggest, and what is disputed, in fact, is whether or not he had specific knowledge that by calling in, the respondents have alleged that he called in intentionally to evade the breath test. And that's what is disputed, and that's, quite frankly, here, one of the issues is that the NYPD has a guidance or a policy, so to speak, where they don't test officers who are on sick leave.
Right. And did he not know that?
That is our contention, that he did not know that at that time when he called in sick.
Sir, was your client, notwithstanding his distinguished record and history at the NYPD, did his status change at this time? It was probationary, correct?
He was on probation.
So it's being a probationary employee, would you agree that's a very different status than the one he had before he went through that whole process after his DWI?
I would not disagree that it might be a different status, but the case law still
that
applies.
status, well, if someone's probationary, that sort of puts them in a category of almost like at will, and so that they may not necessarily be entitled to the same kind of treatment that he would have had before that probationary status. Do you agree or disagree with that?
I respectfully disagree, Your Honor, only because, again, the court in Pell does not make that, does not distinguish in that degree. And the fact of the matter is that what was alleged, that the conduct that he did, the so-called refusal to take a breath test, he called in sick. The NYPD has a policy: if you call in sick, we don't take your breath test. He was there. He was willing and able to, standing before the officers of the PBI, saying, "I'm willing to submit." They said, "No, we can't," and that was the end of it. And it was only about, I guess, he returned to work at some point, and then about a month later, he was summarily terminated. Mind you, when he went back on the job, clearly an indication that the respondents have no qualms about what his credentials are and his reputation is, because they put him as a supervisor. They put him back in. He only learned what the charges and specs were as to why he was fired in opposition to the Article 78 that he had to commence. And they did not terminate him for a violation of the negotiated settlement agreement that was previously executed. They fired him based on new charges and specifications. So, again, it's one of those things where the NYPD is making these rules and then saying, okay, we have a rule, we're not going to test you, and because we didn't test you and because you didn't submit to a test, we're going to fire you. And that's just not fair. It's inequitable.
We do have, though, that call to the counseling unit as well.
He did call the counseling unit. And again, I think that actually works against the respondent's argument because they allege that he called looking for assistance and how to so-called beat the breathalyzer test. Meanwhile, he had already called in sick, so he would not have had to do that if that was the actual truth of the matter. And the reality is, they shouldn't even been looking at those confidential records of the the grievance, where they.
Right, that there was some privilege to that statement.
There was a privilege there.
It was there because it wasn't germane to treatment. It was more like, how can I avoid the bad consequences of what may
Well,
happen.
again, that's entirely in dispute in terms of what was said. And again, without getting further into it, because I don't want to waive any type of privilege with the counseling unit, the intention of the counseling unit is to protect them. In the patrol guide, it says, we will not disclose to anybody what is said to the counseling unit. The Venice report that they rely so heavily on, and so the lower court did as well, specifically says there's an unidentified individual of the counseling unit. Who is this person that claims that this was said? There's no sworn statement. We don't even know his name. And the fact that the lower court didn't even have argument on this to resolve some of these issues of fact. May I just finish this one thought?
You'll have time in rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court, Eva Jerome for the New York City Law Department on behalf of respondents. Foley was on dismissal probation because he had pled guilty to departmental charges of drunk driving and leaving the scene of an accident. He was given a second chance being on dismissal probation. He violated the terms of his settlement agreement, and he was terminated.
Counsel, he did pass 3 unannounced drug tests, correct?
Yes. It's not quite in the record, but he contends so, and I have no knowledge otherwise. But he does admit that he drank the night before the morning in question. He acknowledged when he signed the dismissal agreement, the settlement agreement, he acknowledged receiving a copy of the patrol guide section that says, if you call in sick, we will not be breath testing you. He was not scheduled to work that day, but he called in sick anyway. He admits he called in sick after being told the investigators were there to give him the test. They were only 4 miles away. He nevertheless left and went to Walgreens. The video surveillance raised additional suspicion. And when he returned, he immediately volunteered that he had called in sick and then claimed that he forgot to tell the 2 testing officers that he had called in sick. But he hadn't yet. The phone call logs show that he called in sick after the testing officers arrived to test him, and he knew that. He smelled of alcohol, the investigating officer said. That the fact that he admits that he had been drinking the night before and the fact that they reported that he smelled of alcohol supports the credibility of those 2 officers who made that report. Termination does not shock the judicial conscience here because he had already agreed explicitly that termination was a very real, possible, and foreseeable consequence once he signed the settlement agreement and settlement of the charges.
Counselor, do you rely at all on the statement, the purported statement that Mr. Foley gave to the counseling unit? I haven't heard you mention it yet, and if you did, I'm sorry, but do you...
No, I haven't mentioned it. I don't think it's necessary. There's nothing to indicate that that was the sole criterion on which the NYPD concluded that he had violated the the settlement agreement, and I also do maintain that to the extent he called and said, I need help in avoiding the breath test requirement, that's not seeking counsel, and so it's not privileged. The deference is due to the NYPD disciplinary matters, and his claim that oral argument should have been rescheduled has no merit since he was not entitled to a hearing in any event, and oral argument is just argument, not an evidentiary hearing. And he never challenged, in his reply papers below, he never challenged the investigative report that the NYPD offered in opposition to the petition. This case is just definitely distinguishable from Vecchio, on which Foley relies. Significantly, Vecchio was not on dismissal probation at the time he was found guilty of charges. There are other distinctions, including 13 medals. There's no evidence in the record here of Foley's having received medals. He claims he got 4.5s out of 5s and was highly regarded. In any event, he was on dismissal probation. It was expressly contemplated that he could be terminated at any time for no reason at all, or any reason at all, for almost any reason except bad faith. He received a copy of the patrol guide when he signed the settlement agreement and acknowledged that he understood it as well. If there are no further questions.
Thank you very much.
Thank you.
Thank you. If I may, just to correct a couple of items that opposing counsel just said. First of all, he was not terminated for violating the negotiated settlement agreement. In fact, the negotiated settlement agreement specifically says that if Foley's blood alcohol level was found to be a 0.04 or more, that did not occur because no test occurred. Also, Foley refused
Doesn't
such...
the standard, though, bad faith, it doesn't really matter what the reason was, as long as it didn't terminate from her bad faith reason. What's the bad faith reason you're articulating?
Well, it's not even just the bad faith. It's also the arbitrary capricious component of this, that the fact that they looked at things and saying, okay, well, what are the facts here? The facts are he did not refuse the test. The fact is that he was actually standing there ready, willing, and able to. The NYPD refused to test him. That's what the facts are. So that's arbitrary capricious. In terms of abuse of discretion, that comes in when we're talking about how the punishment is so shocking to one's sense of fairness. Not shocking to the judicial conscience, mind you, shocking to one's sense of fairness. And if we're talking about fairness here, I would like to address the court with respect to the matter of Vecchio that opposing counsel brought up. Matter of Vecchio was a decision that came out of this court. Quite frankly, it's disturbing to even discuss what happened in the matter of Vecchio, but I will try to get through it. This court said that what Officer Vecchio with the police department had done was so-called, quote-unquote, unseemly and repellent. I state for the record what Vecchio did was took nude photographs of two women. One was an arrestee and one was a rape victim. He used the shield that he wears under that assumption to get a rape victim to take pictures, nude pictures of her. An arrestee saying, oh, we need pictures of your bare chest just in case this thing escalates further. It would be nothing but a travesty of justice, and I use that language in my papers, if somehow this court were to say, you know what, Officer Vecchio, you did.
Thank you.
You did those
We get
things.
the point you're making. Thank you very much.
Thank you.
Turn 4.
Roger. Roger.